Hello, my name is Craig Zemke. I'm the supervisor for data with the Children's Services Division of the Chicago Department of Family and Support Services. Welcome to the Head Start Early Head Start Eligibility Requirements training. This training is required for Head Start and Early Head Start staff who are involved in any way with determining eligibility for programs, as well as for program governing bodies, including the Board of Directors and any parent policy council or committee members. So if you are watching this training now and you're aware of other people with your organization who are in those roles but have not seen this training yet, please refer them to it because it is required. So just briefly, let me go through what we're going to do today. We're going to discuss the background of this training and why we are required to give it. Go over some of the changes that were made to eligibility requirements beginning about 5 years ago. So those will be changes in the documentation that you're required to keep, including evidence of third-party verification, a new definition of family that was put into the standards, a more detailed definition of foster care, clarifying who counts and who doesn't count for that category of eligibility, the new rule for homeless families and how we treat applicants who are homeless, required policy on violations that agencies are required to develop, and the training requirements for all agencies participating in Head Start and Early Head Start. So the background is just this. In 2010, the U.S. Government Accountability Office had a fraud investigation in which they sent secret shoppers, essentially. So they attempted to register fictitious children as part of 15 undercover test scenarios, and they did this at centers in 6 states and the District of Columbia. So out of these 15, there were 8 instances in which staff at these centers fraudulently misrepresented information, including disregarding part of a family's income to make them look eligible when they were in fact over income. And 7 Head Start employees lied about applicants' employment status or misrepresented their earnings to make them appear eligible. Because of this, we went from a system where staff signature was good enough to document eligibility to having new requirements for what kind of documentation of eligibility that we require to keep. The program must keep eligibility determination records for each participant and ongoing training records for program staff. The program can keep these records electronically. It doesn't have to be on paper. Each eligibility determination record must include a few things by law in order to be valid. So it must contain a statement, and the statement will be program staff documenting the reasonable efforts that they made to verify information. In order to be valid, the determination must include an interview. This can be conducted in person or by telephone with the family discussing eligibility. There must be a statement of verification that includes why they're eligible, including age, income, or categorical eligibility. And in cases where there is no income, the agency needs to show that they made reasonable efforts to document that, including through third-party verification, calling family members, so on. So if a family doesn't have proof of income, the family can accept a family member's written declaration that states the family doesn't have income or can't prove income. In this and other instances, program staff are required to make efforts to verify that this is true. So as part of this, we at the department don't approve of agency-developed forms to declare no income or categorical eligibility. In other words, we don't want a canned statement that says, I have no income, where the family just signs. We need them to make their own statement, and you can assist them with this if necessary, but it should be, something that they've written out, not just a signature on a form letter. So when we talk about categorical eligibility, and most of you in Head Start realize that that means homeless families, foster children, recipients of TANF or SSI. Those groups are categorically eligible. That means that you don't have to prove their income level is below poverty for them to be eligible. You have to describe the circumstances of their eligibility. So how are they homeless? Where are they spending the night? What efforts did you make to verify this, including any third parties that were contacted? And this is a narrative, not just a signed form. So it should say, I called her mom and talked to her about crashing on the couch, or however you put this, but it would be specifically who you contacted, who did it, when, what they said. So this is a difficult task. So conducting third-party verification, you need to make sure you treat families in challenging situations with dignity and respect. Don't put families at risk of harm in order to verify information. So when we say document your efforts, if there's something that would be a threat to the family, or you might do them harm by contacting them, it's all right not to continue with the verification, but you need to document that and have it in a folder. When we say harm, it may include domestic violence, loss of housing, loss of other benefits, or the risk of stigma or discrimination. So you need to work with families also to obtain consent before you talk to anyone else. And if they won't give it to you, then they won't give it. Now, the next section is the new definition of family. So family has been clarified to mean all persons living in the same household who are supported by the child's parents or guardian's income, who are related to the child's parents or guardians by blood, marriage, or adoption, or are the child's authorized caregiver or legally responsible party. And family for a pregnant woman means all persons who financially support the pregnant woman. This means that if you have an applicant who's living with a relative and the applicant isn't supplying them with income, in other words, most common, the parent is staying with her mom when they apply, that person they're staying with does not count as part of the family size, and also their income does not count towards determining eligibility. It's only people who are dependent on the primary caregiver who should be included in the definition of family and the family size. Similarly, the definition of foster care has been clarified. Foster care, from the federal point of view, means 24-hour substitute care for children placed away from their parents or guardians and for whom the state agency has placement and care responsibility. This includes, but is not limited to, placements with foster family homes, foster homes of relatives, group homes, emergency shelters, residential facilities, child care institutions, or pre-adoptive homes. And the feds have clarified this because many of these policies are at the state level. It's different state to state, so rather than make individual definitions, they're just saying anyone who's in the system. Essentially, this means if a child has a DCFS ID and has been placed anywhere outside the home from their parents or guardians, they count as a foster child. Any of these situations. So a child who counts as a foster child, according to this definition, regardless of whether the foster care facility is licensed or payments are made by the state or local agency for the care of the child, whether adoption subsidy payments are being made prior to the finalization of adoption, or whether there's federal matching of any payments that are made. So all of those things are not taken into account. In any of those situations, the child counts as a foster child and is categorically eligible for Head Start and Early Head Start. Now, the new rule for homeless families came about because the other documentation here that's being required might make it more difficult for a homeless family to apply because they may not have all of the documentation that you're asking for. So the rule is like this: if a program determines that a child is categorically eligible due to their homeless status, a program must allow the child to attend the Early Head Start program or the Head Start program, even if they don't have other required documents such as medical records, immunization, proof of residency, birth certificate, and so on. The program needs to give the family a reasonable time to come up with these documents. And I would add, if they don't have them, the agency's responsibility should be to help the family acquire these documents. That means that nothing in the regulations should be used to make it more difficult for homeless families to enroll in a Head Start or Early Head Start program. So again, staff should work with the families to acquire anything they don't need or anything they need that they don't have, a birth certificate, and so on. You need to help them find it rather than exclude them from the program until they come up with it. So the next piece of the new regulations were that there is a required policy on violations. That means that each program, each delegate agency must establish policies and procedures that describe all actions taken against staff who intentionally violate federal program eligibility determination regulations, and specifically if they're enrolling children or pregnant women who are not eligible to receive Head Start or Early Head Start service. DFSS doesn't directly determine eligibility, but we do monitor ERCIA matters for agencies. ERCIA is, of course, Head Start shorthand for eligibility, recruitment, selection, enrollment, and attendance. So our policy has been that children whose eligibility was not determined to be in compliance with regulations are not considered an allowable expense. So essentially, if you accept someone and it turns out that this was fraudulent from our point of view, that the family was not actually eligible, the money that was spent on them isn't allowable, and we may be asking it back. Something similar can happen to us at the federal level if we have a review and determine that we admitted children who are not eligible. But in terms beyond that, in terms of what the policy will be, like what kind of actions you would take towards staff members who did falsify eligibility or otherwise not act in compliance with the regulations, is something that the program needs to determine. What I will say about that is that whatever the policy is, it needs to be applied consistently to all staff people, and not, I mean, you can't fire one person for doing this and not take any action against someone else. That everyone should be treated according to the guidelines that you have written up as policy. So think about that and make sure if you don't have a policy, when you write the policy, that it reflects what you're actually going to do. And then once you have it in writing, you're going to follow it. Now, training requirements. A program must train all governing body, policy council, management, and staff who determine eligibility on applicable federal regulations and program policies and procedures. I am doing that right now. So if you are on one of our governing bodies and you are viewing this video, you are taking part in the required training. You'll see on the next slide, I'm trying to cover everything here that I'm supposed to cover in order to make this legally acceptable training in compliance with the regulations. So required training must include several pieces, methods on how to collect complete and accurate information from families and third-party sources. So beyond what we say here, if you have specific procedures about who determines eligibility and how that is done, that should be included in the agency-specific training. You also need to incorporate strategies for treating families with respect and dignity, and for dealing with possible issues of domestic violence, stigma, and privacy. What this is referring to is that when you set out what your policy is going to be towards third-party verification, verifying, for example, homeless status or other eligible status, having no income, and so on, you will want to make sure that they're not causing harm. Again, so if they say, don't call my employer, I don't want him to know, maybe he doesn't know that she has a child. Maybe he don't want him to talk about the income because she's being paid under the table and it doesn't meet minimum wage law or something like that. So there may be circumstances in which calling the wrong person can cause the family harm. So you need to be careful about that. And again, a big piece there is you need to have consent before you talk to anyone. And then the third piece will be the policies and procedures. You'll explain your program policies and procedures, including those that describe actions taken against staff, families, or participants who intentionally attempt to provide false information. So again, when you come up with that violations policy, you need to tell everyone what it is. Nobody should be surprised if there is disciplinary action taken because of this situation, because inaccurate information was used to determine eligibility. That should be covered in the training, and so everyone knows ahead of time what the consequences would be. So when does this have to happen? A program must train management and staff members who make eligibility determination within 90 days of hire. So if you hire a new family worker who's going to be interviewing families and determining eligibility, within 90 days of their hire date, they need to receive a training on eligibility policy. The program must train all governing body and policy council members within 180 days of the beginning of the term of a new governing body or the term of a new member. And obviously, that's been difficult in the current situation, but that is the regulation that we're trying to follow going forward. A program must develop policies on how training will be provided after the initial training. That means that if you hire someone and you give them the training within 90 days, you can't assume that they're going to remember it 10 years later. So every so often, the training should be reinforced, and there should be additional workshops on the eligibility requirements. So again, we're not going to dictate to you what that schedule would be, just that it should exist. I'm hoping that, because we've been saying this for several years now, I'm hoping that you do have these policies already developed, but if not, that you need to have them developed at the very latest by the time that we have the next federal review, but hopefully sooner than that. Okay, so the conclusion, these eligibility regulations were not meant to be put in place to put additional burdens on families. So as I talked about at the beginning, the investigation was an investigation of agencies who were not determining eligibility correctly in compliance with policy. So they're making certain that we can all document that we are doing what we're supposed to do. This is not supposed to make it harder for families to enroll. Families are not the ones who are under suspicion. Grantees and delegates are under suspicion, because almost half of them, when they did the secret shopper routine, were discovered to be doing things that were not right. I don't know if they just picked a bad bunch, but that was a very high rate of fraud that they were finding. I will want to point out that of the states that took part in the investigation, Illinois was not one of them, and no one among our programs was ever found to be doing anything untoward with regard to determining eligibility. But around the country, many were. I'd also note that much fraud is actually poor documentation. So your determination of eligibility is valid so long as you have documentation somewhere that shows how it was determined, and that in fact the information that you saw showed the family to be eligible. That's good enough. You just need to have that documented. It's only when documentation is missing that it begins to look deeply suspicious. So the last point is, be sure to document your efforts to verify eligibility, and you'll be in compliance. So if you call someone, there should be a note that said, we called so-and-so. And I mean, we do try to make this simple by collecting a lot of the information on the form that we call the HSEV, the Head Start Eligibility Verification Form. But you do know that everything that form says that you have in the folder should be in there. So if it says we determined eligibility because of a letter, we should see the letter. If it says check stubs, we should see the check stubs. They should all agree, and that's how we'll know that you're in compliance. All right. Well, thank you very much. I appreciate your time. And again, if you know anyone else at your program who meets the criteria for being one of the people who should be trained, on eligibility and they have not done so recently, I urge you to direct them to this video so they can also take part and we're all on the same page going forward. Again, thanks a lot and have a wonderful day.